Hello, everybody. Welcome to the Supervised Visitation Network webinar series. I am Executive Director Joe Nullett, and I am thrilled to introduce our presenters today who are going to talk about domestic violence is more than physical violence, examining the role of coercive control. And today on the call, facilitating this fantastic information is Cory Hernandez and Dr. Mindy Mechanic. Cory is a staff attorney at the Family Violence Law Center, pardon me. And Dr. Mindy Mechanic is a professor at the Department of Psychology at Cal State Fullerton. So you guys know the drill. We have the chat room is open. Feel free to ask questions at any point if it makes sense. I will pose your question to our facilitators. The handout section right next to chat has today's PowerPoint already for you, has full bios for our presenter that you can take a look at, and some other information that will be helpful. So welcome once again, and thank you to our facilitators. Without further ado, I will turn it over to you.
Thanks so much, Joe.
Thanks, Joe.
Mindy, do you want to quickly introduce yourself and your pronouns?
Sure. Hi, I'm Mindy Mechanic. I'm a clinical forensic psychologist and fairly recently retired professor from Cal State Fullerton.
Thanks. And just as I'm Cory Hernandez, a staff attorney at the Family Violence Appellate Project. I used to work at the Family Violence Law Center, also in Oakland, but now at the Appellate Project. So, and I use they, them pronouns, calling from Ohlone land here in Oakland. So today as we said, the title of our presentation is on focusing on coercive control. Just wanted to note one thing. We've given this presentation before, and we're happy we sort of redesigned it over the years and kind of updated it for this audience. But as we go along, if there are questions or points that people want to raise, please feel free to do so in the chat. I see people are introducing themselves. Thank you. And then towards the end, we'll have some polls with some of our hypothetical situations. Okay, let's dive into it. So for today, we just went through some introductions. I'm gonna go through a bit of a just brief overview of the law, not only California, since that's where I practice, but trying to look at state by state, since this is a national group, and trying to see sort of where the trend is going. And maybe some tips for people who want to advocate for improving, their policies in their states. And then we'll kind of jump into some social science, where Mindy will talk about some of the more recent research on what does coercive control look like, not only how to regulate around it policy-wise, but what does it actually look like in the field. And then we're going to jump into some hypothetical scenarios. We have about 6 of them. As you see in the slides that have already been shared with you, we may not be able to get to them all just with the time we have, and that's fine. We encourage you to work with them on your own if you have time and want to do so, or talk with colleagues. And then, of course, we'll have a question and answer at the end. And also, my contact info is available for any further follow-up afterwards. And we also have a handout with some social science articles and reviews that Mindy's prepared. And in the actual presentation itself, underneath the slides are the presenter notes, where we have a lot of additional information, a lot of citations directly relevant to the slides, and just some additional info that may be useful. So jumping in, just quickly say who we are here at FAB. So I'm one of the attorneys, and Mindy is on our advisory board. She's been working with us for a while. And so we at FAP, we're based in Oakland, California, but we focus on California and Washington states. And we're a nonprofit. We're dedicated to providing legal representation for free to survivors of domestic violence, sexual assault, stalking, human trafficking, and elder abuse at the appellate court level. So if they have something goes wrong at the trial court level, if custody is granted to an abuser or a restraining order is denied, or the court denies them damages from a civil lawsuit or something like that, we may be able to step in to help them. We partner with pro bono attorneys to do so because appeals are resource intensive and they take a long time to be able to provide that free, high quality representation and focusing on low and moderate income survivors, the majority of whom so far of our clients have been survivors of color. We provide technical legal assistance as well to attorneys and non-attorneys, so advocates, and others who work with survivors in any capacity on any issues that arise in civil cases. So family law, restraining orders, housing. And we may be able to, even if you don't practice in California or you don't have you don't work in California or Washington, we still may be able to help you or at least connect you with a good resource that we know of. Okay. So we'll jump into some legal definitions. Just a quick note. Of course, even though I am an attorney, I'm not giving legal advice here. This is just information, based on what we've researched, but it's not a substitute for your individual cases. What would be good advice for that particular case. And as I said, I try to do a state-by-state analysis, trying to look at different states, how they define abuse. And as we'll see, there are some trends across the states and some unique ones. But this is an area of law that changes so quickly. And even now, there may be pending bills in your state or your jurisdiction that I don't know of. So I'm sorry if this is maybe out of date by the time you get this. So first, I just kind of want to look at across the nation, what does the definition of abuse look like? Because we know that family law is it's not really federal. It's more of a state level thing. That's why a lot of custody laws, restraining order laws, divorce laws vary state by state, and there's no sort of federal governance over that. So what does this definition of abuse look like in the law? Well, first, it's important to note that we're going to be looking at the civil definition, not criminal. So we're looking at really family law, that's with divorce, custody, support, and restraining orders for most states. And pretty much all definitions include physical violence, threats, and sexual assault. Some are just those. Some states limit the definition just to those behaviors. Many, and as I said more recently, have been trying to expand to include more non-physical acts and other types of crimes. As I said here, burglary, theft, arson, trespass, destruction of property. And others have even gone more capacious, trying to get things like harassment, criminal harassment, animal abuse, child abuse, stalking, violating a restraining order itself, and then disturbing the peace. So, these are very broad terms. They can encompass physical abuse. Of course, pushing somebody, punching somebody can harass them, can disturb their peace. But it's not just limited to that. So that's the important takeaway of today, is that all these forms of abuse can include non-physical behaviors as well. So starting with California, since that's where I practice, and I can kind of speak the most to, but we'll kind of compare it to other states quickly. So here in California, we probably have one of the most broad definitions in the country from what I've seen. We include disturbing the peace, not just criminal disturbing the peace. We have a more broad definition of the civil standard, which most other states don't. And as it's defined here, is destruction of somebody's mental or emotional calm. And it can be committed directly or indirectly using somebody else, like the abuser's friend or family member, through any means. So not just in person, but also over the phone or email, social media, stuff like that. And importantly, we just recently passed a bill that went into effect this year that clarified that disturbing the peace includes coercive control. And it's defined here now in California as a pattern of behavior that in purpose or effect unreasonably interferes with somebody's free will and personal liberty. So it's a very broad definition. It doesn't really give you a lot of guidance. So what the legislature did is sort of give some examples. And we'll see this in other states as well, like Hawaii and Colorado, because the definition is pretty broad, and as you can probably imagine, that can encompass a lot of things. So they give some examples just to sort of narrow it down just a bit, while not being an exhaustive list. So one thing is isolating somebody from friends or relatives, sources of support, depriving somebody of basic necessities, which is not defined in the law, but basically would probably include things like food and water, clothing, shelter, medical, remedial care, things that you need to survive, to live. Controlling or monitoring somebody's movements, their communications, their behavior, finances, access to services or resources. And then this sort of catch-all, using force, threat of force, or intimidation, including, importantly, threats based on actual or suspected immigration status to make somebody do or not do something. So again, that's a very broad sort of definition. You'll see that it includes immigration status. It's the first time, at least in our law, that it's been expressly included a threat based on immigration status, which we think is very important. And we've seen a couple other states have been trying to pass bills doing that as well. Of course, the definition. So just also wanted to note in this definition that it only encompasses behaviors that are unreasonably done in nature. And that was done on purpose, specifically for the legislature to not encompass behaviors that might be preventing somebody from doing something they want to do. There might be reasonable scenarios in which to do that, preventing somebody from harming themselves, preventing a child from doing something that may be risky, disciplining a child by taking away their allowance. Things like that are reasonable, that would otherwise fall in the definition, to not be covered here. Okay. So as I said, California is one of the few states that has expressly identified coercive control in the law very recently, and Hawaii also very recently has done so. Again, other states have pending bills to do so as well, and these may be some good examples. Here's the Hawaii definition, and you'll see a lot of similar language, which I've tried to emphasize with bold here. So here they define coercive control as a pattern of threatening, humiliating, or intimidating actions. Interestingly, California does not have that term humiliating, which I think is probably a bit more broad in Hawaii, which is maybe more helpful for survivors. And this can include assaults, other abuse that is intended to harm, punish, or frighten somebody. Important to note that it's a pattern, as we'll talk about sort of later with more of the social science, kind of differentiating between what we're talking about mostly here is coercive control as a pattern of behavior or relationship versus more one-time incidents, which may be more referred to as like situational couple violence, that it depends on the situation or it's a one-time situation. Both are forms of abuse. Both should be considered abuse under the law, and should be restrained appropriately in appropriate cases, and taken into account for things like custody and support. But it's important to recognize for coercive control in particular, just how much more challenging it could be for a survivor in that situation when they're stuck in that pattern, and we'll sort of see why. But it is important to recognize the definition does require a pattern, so it needs to be sort of a repeated act. So here in Hawaii, as it says, it's a pattern of behavior that takes away somebody's liberty of freedom, strips away their sense of self, including bodily integrity and human rights, which is designed to make somebody dependent on the other by isolating them. Again, we see isolation, we see dependency, isolating them from support, exploiting them, depriving them of independence, and regulating their everyday behavior. So again, we see a lot of the same terms, patterns, depriving somebody of liberty and freedom, isolating them from support, exploiting them, regulating them. These are the types of terms, the things that to look out for when you're thinking about a pattern. Sorry, we're also trying to keep track of questions here. See the individual include children. Whether something includes children or not. In California, yes, the definition would include children. And I think in most states that would apply as well. But other states do differentiate between abuse against children and abuse against adults. And actually some states specifically state that their restraining order and other family law definitions of abuse only apply to people 18 or older. There's different definitions for people under 18. Even in California, there are some, just as a note, leeway, as in every state, for certain forms of child abuse that are accepted that would not be accepted if done against adults. But that's kind of different topic. So again, just like in California, Hawaii provides some examples to give some help on what exactly that broad definition covers. What does that mean? Of course, this is not meant to be an exhaustive list. So even if you don't see something covered here, it could still be covered by the definition. So here, these are some examples pulled from the statute: isolating somebody from friends and family, controlling their money and how it's spent, monitoring their activities, their movements. So not necessarily, just stalking them, following somebody, but even just monitoring them using the tracking device on their phone, something like that. Name calling, degradation, and demeaning somebody frequently. Threatening to harm or kill somebody or their child or relative. I would also say even, themselves. Threatening to commit suicide can be an act of abuse in many states because it can harass or disturb somebody's peace. There are some specific cases on that, including here in California. Also in Hawaii, they have threatening to publish somebody or publish information or make reports to the police or authorities. So that again kind of encompasses threatening somebody based on their immigration status, or it could be threatening the other parent. I'm going to tell the police that you abuse our child, tell CPS that you sexually abuse our child, trying to make these false reports, threats, or damaging somebody's property or household goods, or forcing somebody to take part in criminal activity or child abuse, which is sometimes referred to as criminal coercion. We'll see that in some other states as well. And then would, of course, just wanted to mention, as we said, trying to compare Hawaii and California, the two states that kind of expressly state coercive control is covered, and kind of which one is maybe broader, which one is, are there differences? To me, they kind of read very similarly. Yes, Hawaii does list out some more examples, and I think that may be useful in California. At the same time, when you really compare the terms using their definitions and think about the behavior that would be encompassed by one and the other, to me, they're almost the same. And especially in California, just given our robust case law on interpreting things like disturbing the peace and harassment, I think a lot of these behaviors, even if they're not expressly covered in the statute, could be covered. And that's a good point for other states as well. Even if your state's definition does not use the term coercive control, or doesn't use any of these terms like isolation or monitoring somebody's movements or demeaning them or controlling their money, depriving them of support, even if your state doesn't use any of that, your case law and how courts interpret those statutes could actually show that your law is broad enough to cover these behaviors. And unfortunately, I haven't had time to actually look into all that case law, but I'm sure attorneys in your state would be able to help with that. But kind of looking at those other states, what do they include? As I said, none that I could find expressly include the term coercive control. Of course, as we're going to talk about, that is a term of art that was developed in the social science. So it may just be that people aren't aware of that specific term, or people prefer different terms or not using this phrase. For instance, Colorado and Missouri are pretty close in terms of this is just part of their definition of abuse that I pulled out, because to me, these definitions read very similarly to the definition of coercive control without using that express language. So you'll see it's about compelling somebody with force, threat, or intimidation to do something that they have a right to abstain from, or to abstain from doing something that they have a right to do. So again, very broad definitions. They don't give examples like California and Hawaii, and other states also include criminal coercion, or coercing somebody by force, threat, or intimidation to do a crime, like Alabama, New York, and Washington. Okay. And just lastly, would note that we're mainly going to be talking about, parents with survivors in relationships with children in common, just given the network. So I think that's these definitions of abuse will cover this situation in all states. But there are different types of relationships that different states consider domestic violence and some don't. For instance, every state considers spouses and ex-spouses and parents with children in common as like sort of domestic enough or intimate enough to be domestic violence. Some states include partners, like romantic partners, sexual partners, like boyfriends and girlfriends. Some states don't. Some states include fiancés, and some states don't. So it just kind of depends. You'll kind of have to depend on your state. Just wanted to flag that for people to kind of be aware of. Okay. Jump into the social science. Mindy?
Yeah, thanks. So as social scientists, we've been looking at coercive control in one way or another for, I want to say, close to 15 years, thanks to Evan Stark, a researcher who really put coercive control on the map. Cory, do you remember when his book was published? I want to say like 2007, around there, but I can't remember.
Yeah, mid-2000s, around there.
Yeah, so, ever since Evan put out his book, I think it spawned a lot of additional research on the topic of coercive control. And researchers have defined it differently. I'm not going to get into all the different ways social scientists have defined the construct. But I think what's important to remember, and Cory, you telegraphed this earlier, is that it's really a lot less of an incident or act-driven type of phenomenon. And I like personally to think of it as a relationship dynamic. And we'll get into this more when we talk about some of Michael Johnson's work, but that it tends to be expressed in many different ways, in many different types of acts. That could include physically violent acts, but often includes acts that are not physically violent, but that are on the spectrum of emotional or psychological abuse, but where the motivation of those acts is for one partner to gain control or compliance over the other partner by instilling harm, by creating a climate of fear, by creating a climate of deprivation. And so the victim learns that the way in which he or she can be the most safe is to comply, is to not resist, not go along with, to go along with what their partner wants, to not resist, not refuse, but compliance, essentially, compliance with the requests as they're made. But also people learn, in order to avoid harm, is to comply in advance, to do things they know in advance that won't set their partner off. So I think when Evan Stark talked about this in his initial book, and Cory, you highlighted this in the laws that you talked about, that fundamentally what coercive control does is create a climate of coercion and oppression where somebody's agency, their free will, is vitiated. Because if you've learned that by expressing your free will, some sort of harm, emotional, physical, whatever type of harm will come to you, that teaches you not to exert your free will. And in that way, coercive control functions as a form of oppression. Okay, thanks. Next slide. So we don't have a slide here on physical violence. Everybody knows that it's part of the spectrum of intimate partner abuse. But I just like to say that the way I always think about it and the way I've researched it is to think about intimate partner abuse as consisting of 4 different categories or types of abuse. The first one being physical violence, and people know what that looks like. It could be anything from minor stuff, pushing, slapping, shoving, all the way to lethal violence that can take somebody's life. The other categories, which we'll talk about now, this one being emotional and psychological abuse. And when you look at the range of actions that comprise emotional or psychological abuse, you see that it's a very broad, probably the most broad of the 4 categories of abuse. And that the examples that we've listed on the slide map very well onto a lot of the examples or the definitions that Cory talked to you about in the coercive control statutes. So things like being possessive and jealous of your partner, isolating them from other people, restricting their movements, Gaslighting is a popular one these days. I don't know if people are familiar with the term, but basically it means acts that convince the survivor that their perceptions are inaccurate or false. So things like telling a person that they're crazy, they're imagining the abuse, that it's not really real. It can lead them to start to doubt their perceptions of reality. You know, I've personally have worked with a lot of survivors of intimate partner abuse, and without exception, I've always heard from them that there's something that's very telegraphic and very obvious about physical violence and injuries, where you don't doubt the veracity of your perceptions and you know what has happened to you because you can see the scar. And the act itself is very clear to you. But there's something much more insidious about emotional and psychological abuse that makes it much harder for people to always identify or define as a form of abuse. Okay, anyway, so excuse me. Additional acts can include things that are somewhat violent, like destroying a person's property. I see a lot of situations where things like cell phones are destroyed, or things that relate to a victim's prior history with another partner. So wedding albums or gifts from that other partner as a form of jealousy, those things can be destroyed. But a partner can also engage in acts of emotional abuse by threatening to leave the relationship, threatening to commit suicide if the partner leaves, threatening to kill the partner or her kids, her pets, her family members or friends. I'm saying her just because it's easier, but I do recognize that anybody, male, female, transgender, can be the victim of intimate partner abuse. Threatening to the person that they better drop charges or drop the restraining order. If anybody's interested, reach out to me later. There's some really great research by a researcher named Amy Bonomi, and she's looked at jail calls between abusers who are incarcerated in jail and their victims, their children or their victims' children or third parties, to articulate the ways in which those abusers use those calls to try to manipulate their victims into backing off, into dropping charges, or really coercive control, into doing what they want them to do, even from afar. So despite the fact that there's a separation and the fact that the abusers are even in jail, that doesn't necessarily stop the abuse from being transacted through third parties or directly. Threats to call CPS on the victim, threats to call police on the victim. I've seen cases where abusers have scratched themselves or cut themselves and called police and said, hey, this is what my partner did to me, to get them arrested. Threats to out somebody to ICE and get them deported. There's a ton of ways in which children can be used as pawns, both while the relationships are still intact. But this is one of the ways in which separation abuse can continue well after a person has left the abusive relationship. And this is something that I'm sure many of you folks are familiar with, and one of the reasons why supervised visitation can be ordered, because there's so many legitimated opportunities where abuse can continue directly or through the children during custody exchanges or visitation. And then finally, intimidation with words or gestures. Again, this is one of the reasons why mediation, let's say, in the context of custody, has often been considered not a very good or safe idea to approach when there's been a history of abuse, because mediators might entirely miss the nuanced gestures that are going on between two people, such as a glance or a gesture that can signal to the victim that they better go along or they better capitulate, things that go right over the heads of the of the mediators, not because they're not savvy, but because there's what Carla Fisher wrote about decades ago. She called the culture of battering. So basically the nuanced dance and the nuanced culture that exists between the two parties, where things signal to them, acts can signal or gestures can signal danger on the horizon, or you better go along with me or else, that other people wouldn't necessarily be privy to. So that private dance and private exchanges can be really important, and outsiders might miss that. Okay, next slide. Okay, so the third category of abuse, and again, this can overlap with coercive control as well. There's all different kinds of stalking and harassment that can take place. And again, research has borne out the fact that these types of behaviors exist both in relationships that are ongoing, abusive relationships that are ongoing, as well as post-separation. This kind of behavior, stalking harassment, can even increase post-separation. So it can take many different forms, surveillance or monitoring of an individual. That can look like anything from calling them a zillion times a day, installing GPS tracking devices, making them provide receipts, like gas receipts for where they've been to account for the mileage on the car, sitting in a parked car outside their house or their job. It can include violations of restraining orders, intercepting mail or email, unwanted visits. You know, it's one thing to get flowers from somebody, from a lover or partner, and have it be something desirable. But when you've broken up with somebody and they send you bouquets every day, it takes on a very different complexion when those visits or gifts are not wanted by a person. Sexting is another thing that's a little bit on the newer side of technology and inappropriate intrusions. So, you know, sending naked pictures, texting them to a person is an example of that. One thing I wish we had a lot of time to dig into, because I think in the digital age, there's all kinds of ways in which technology can be used to facilitate abuse as well as coercive control. I'll talk in a little while about revenge porn, and that's one of them. But there's so many different ways in which we've all witnessed technology being used as a form of control. And finally, abusers can hack into their victims' email, social media, and they can pretend to be that person. They can post sexually inappropriate pictures of those people, put their names on it. They can use whatever they hack into as a way to antagonize or threaten or act jealously. So there's a whole range of stalking and harassment behaviors that can be coercively controlling. All right, next one. So the fourth category, looks like this slide got a little messed up here. The fourth category consists of various acts of sexual coercion and violence, ranging all the way from rape and sexual assault to non-consensual porn, which I'll talk about a little more later, insisting on having sexual intercourse without any type of protection, being made to watch porn, being made to watch other people engage in sex, or being made to have sex with other people while the partner watches, being forced to walk around nude or being forced to wear sexy clothing, kind of the opposite of some of the jealous things you see with emotional abuse, where abusers will tear up any sexy clothing that belongs to their partner. They don't want them wearing shorts or halters or anything they think of as too revealing. This is on the opposite spectrum of that. Okay, and finally, I'm not really sure which category to put this in. I basically stuck it on the end of the sexual coercion slides, but it could be a form of emotional abuse as well. But research has identified specifically issues relating to coercion in the reproductive context. So this can include a number of different things, including removing a condom during sex, referred to as stealthing, which I'll just say for those of you who haven't heard, the governor of California, Governor Newsom, signed into law a bill the first week in October that imposes penalties, civil penalties, for somebody who removes a condom during sex. Can include, again, damaging a condom, destroying a person's oral contraceptives, or removing their contraceptive patches. Can include refusing to wear a condom at all, or refusing to allow your partner to use any type of birth control. So underlying this are also pressures to keep somebody pregnant, to make them pregnant, to have influence over whether or not they reproduce. Okay, next slide. So if we were focusing on social science, we could probably spend our entire conversation here just talk about measurement issues, but that's not where we're going to go today. But suffice it to say, like I said earlier, when it comes to acts of physical violence, especially violence that leaves injuries, it can be very easy for a person to label and recognize their victimization as victimization. But a lot of the acts of abuse and types of coercive control dynamics that we're talking about don't always map on to how people think of victimization or think of domestic violence. You know, people think about it as black eyes and broken bones. And most of what we've talked about today don't really fit at all into those conceptualizations. So it takes like stepping out of that box to be able to see what for a victim to be able to see what they've experienced as a form of abuse or coercive control. Things like gaslighting are especially nuanced because in a situation like gaslighting, a person might be confronting their abuser saying, you know, why did you do this to me? This is really painful. And yet the abuser is saying, I don't know what you're talking about. You must be crazy. I didn't do any of those things, making it especially difficult for the survivor to be able to say, I was abused, and they start denying their own reality. So if you're talking to a victim about these kinds of things, being able to mirror what the victim is saying using their language instead of the language we use can be a helpful thing to do. I'm not personally aware of any checklists that are good for use in clinical or applied settings outside of research, or at least ones that focus exclusively on coercive control. But there are some other tools that can be helpful, like the power and control wheel, because it does explicitly identify dynamics that are coercive control. So that can be a tool that might be helpful when working with a victim. Also, if folks are doing any kind of risk assessment with survivors who are experiencing forms of abuse that have an increased risk of lethality, things like strangulation, stalking, jealousy. There's various iterations of Jackie Campbell's danger assessment. You could find her webpage. I think it's www.dangerassessment.org. I think that's it. Or just by Googling danger assessment and look at the various tools that she and her colleagues have developed, as well as find training for for the danger assessment. It's also good to just think about the ways in which coercive control affects the victim, both directly in terms of causing harm, but also in terms of the way it functions on the victim to have victims change their behaviors in order to comply or accommodate the wishes, expectations, or demands of their abusers. So one way to do that is to separately look at what types of tactics the abusers are engaging in, and what are the behaviors or the responses that the survivors are engaging in to keep them safe. And victims can engage in a whole variety of behaviors and responses to keep them safe, some of which are more adaptive than others. Okay, next slide. Okay, so as a little backdrop, when we condensed the slides, I think we omitted an overview slide to set this slide up. So I'll just try to do this without a slide. My apologies here. So what I wanted to talk about here was some distinctions that have been made in the literature by originally by Michael Johnson in 2008 in his book, but that has been looked at pretty extensively in the empirical literature by other researchers. So one of the things that Johnson identified is that there's different types of abuse, different dynamics of abuse, and that all forms of relationships in which domestic violence or intimate partner abuse is present are not necessarily the same. So one of the distinctions he makes that's important is the distinction between relationships that he describes as intimate terrorism versus those he refers to as situational couple violence. And for folks who might be familiar with his work, over the years, he's changed the terms that he's used to categorize these different types of abuse. For example, situational couple violence used to be called common couple violence. But I think he wanted to make it more accurate by not only saying it's common, but also that it is incident or situation focused, unlike intimate terrorism. So just for a very brief synopsis here, intimate terrorism is the kind of more severe, more violent abuse that we're more apt to see in shelter samples or in cases of survivors who are possibly seeking protective orders or going for help. It's the kind of abuse that tends to involve fairly serious abuse, often injurious, often very controlling, involving jealousy. And again, the main dynamic here is control. And the situational couple violence is different in a lot of ways, including the fact that the primary motivation in these types of abuse situations involve conflict management. So the goal is not to control your partner, to restrict their movements, to get them to comply with your wishes. In cases of situational couple violence, what you have are individuals who lack the resources to be able to manage conflict, whether that's, where should we eat dinner? What religion should we raise our kids? What refrigerator should we buy? These types of cases involve an inability to resolve conflicts that emerge in the relationship. And because of that, the research also shows that, in comparison to intimate terrorism, which is perpetrated primarily by men, situational couple violence is perpetrated by both men and women. And while you don't tend to see extreme acts of violence, it certainly is possible. But primarily what you see are things like pushing, slapping, shoving, name calling, pretty low level stuff. And you don't usually see people going to the hospital with serious injuries or people experiencing lethal violence when they try to leave their partner. Although, it is possible. So on the left column, you see the list of things that cut across both situational couple violence and intimate terrorism. And those do include acts of abuse that can occur during a relationship, but after the relationship ends as well. Although I do want to say that's more likely with intimate terrorism than it is with situational couple violence, because there's not a need to control the person. So separation can be more helpful unless you've got issues where they're not able to resolve conflicts that are ongoing. In either case, certainly intimate terrorism is more of a relationship dynamic. So by definition, that involves multiple incidents. But situational couple violence can be a single incident, or it could be a range of incidents. Again, because people are not skilled at resolving conflict, those conflicts could continue to erupt over the course of the relationship and result in using actions instead of other types of healthy conflict resolution techniques to resolve the conflicts. Both can cause injuries, but again, more likely with intimate terrorism. Both can have long-term negative effects on survivors. I've already talked about the gender difference. But again, with situational couple violence, it's important to remember that even though men and women might equally engage in low-level abuse, like pushing, slapping, shoving, the physical consequences can be different just based on physical size and strength differences. So a push or slap or shove from a small woman to a larger man has a lot less impact than vice versa. And finally, it's important to remember that both of these types of abuse or violence would be covered under the law, and the remedies could apply in either case, even though we've all witnessed situational couple violence being used as a reason to justify not giving a remedy in the legal context. Okay. Oh yeah, one more thing I want to say about that. So The last thing I want to say about that is there was recently a study published by Love and colleagues, and it was a meta-analysis. A meta-analysis is basically a study of studies. And what was interesting about this study is it was trying to identify intimate partner violence risk factors for situational couple violence cases versus intimate terrorism cases, and to see if there were any differential risk factors that predicted one versus the other. So what they found really maps very, very closely onto Michael Johnson's typology of these two different types of abuse. So they found 5 risk factors for intimate terrorism, and they include stalking, controlling behaviors, jealous accusations, the perpetrator taking all the power in the relationship, and patriarchal beliefs on the part of the perpetrator. So those map very nicely onto how the intimate terrorism subgroup has been conceptualized. But then in contrast, the risk factors in situational couple violence relationships had to do with relationship dynamics that they call demand withdrawal, which are basically like pursuer distancer type of dynamics. So one person's pulling away and the other person's chasing them. Dissatisfaction in the relationship. And finally, poor conflict resolution and poor communication skills. So that meta-analysis done many years after Michael Johnson's original conceptual work, as well as other research, really provides a lot of support for the idea that there's unique subgroups within the heterogeneous pool of intimate partner abuse relationships. Okay, next slide. Okay, so personally, as someone who's gotten involved in a lot of cases involving intimate partner violence, I have to say I'm beyond thrilled and grateful for all the amazing work that people do when they serve as monitors or conduct supervised visitation. It creates opportunities for a lot less abuse to be transacted, and for the children and the survivor to have safety that they wouldn't ordinarily have if they were doing their own exchanges or visitations. But one thing, you probably already know this, is that the most important thing to do in keeping children safe is ensuring the safety of their survivor parent. So by providing supervised visitation and providing support to the survivor parent, that has the increased likelihood of improving all kinds of outcomes for children who are exposed to abuse in their parents' relationships. As I've already said, people used to always think that separation was the answer to intimate partner abuse. And once you're divorced and no longer together, it's not a big deal. But we know that that's not true. We know that not only does abuse persist post-separation, but that the tactics can change and that they often involve children and custody and visitation exchanges. So while supervised visitation encourages parents to be on their best behavior, certainly if in that context where people are expected to be on their best behavior, where people aren't, that gives you some kind of idea of what might be going on when nobody is looking. If they can't manage to get their act together in front of other people, it probably signals what's worse going on when nobody's watching and when they're not supposed to be on their best behavior. So the providers are a very important neutral third party. It's very helpful to have those neutral third parties present, to observe, to ideally to document their observations as to what happens during the exchanges, to document family dynamics. This type of evidence can also be helpful if parents have to go back to court and revisit their custody arrangements. So this kind of evidence can help establish patterns of abuse. It's also important to remember, too, that the person who might be identified as the parent who has the supervised visitation is not always the abuser. The survivor can also be the person who is the recipient of the visitation, the supervised visitation. Okay, next one, Cory. Okay, great. So while it's important to recognize that the supervised visitation and exchanges of services, they're not meant to be interventions. They're not meant to change the behavior of the individual people in it. And so they're one part of a bigger plan that needs to be in place that could include individual therapy for the survivor and possibly better intervention or anger management is ordered sometimes for the abuser. I do want to say, though, that better intervention programs and anger management programs are very different. That, when you look at cases of intimate partner abuse and violence, that for the most part, we do not conceptualize those cases as rooted in or motivated in anger. You might see anger topographically on the surface, but the motivation is not anger, it's control. And so better intervention programs focus more on accountability than on the superficial expression of anger. And so if you look at the ways in which batterers engage in abuse against their partners or even sometimes their children, you see that the kinds of tactics that they're using with the people close to them, the people they control, are very different than the ways in which they engage other people. So, if they're willing to threaten or hurt or intimidate their spouse, for example, you don't typically see those same guys engaging in threatening, intimidating, or menacing behaviors with their friends, with their colleagues, or with their bosses. So that tells you right there that the issue isn't some anger that they can't control, but something else where their behavior is targeted to the vulnerable people who will accept it or tolerate it or who aren't big enough or strong enough to fight back. So I think that provides a bit of a window into the idea that for the most part, batterers are choosing to engage in the behaviors they're engaging in, and it's not just anger that they can't control. I will say that although we don't have time to dig into this today, research has tried to look at the heterogeneity among batterers, and there is a small subset of batterers who researchers refer to as generally antisocial. And those antisocial types are the types who are democratically abusive and violent towards whoever, towards anyone. They're the type that will smack back at the cop who arrests them, who will mouth off to their boss. But for the most part, that's a minority subgroup of the broader population of batterers. So it's important to have a thoughtful, well-delineated plan to transition once the supervised visitation ends. Just like when we release people from prison, there have to be halfway houses. You can't just withdraw a certain type of service or a way of relating and then expect a person or people to manage effectively. So there needs to be a way to shift and transition from supervised visits and exchanges into not having those safety mechanisms in place. And certainly within the legal system, having clear laws, court orders, and recommendations are necessary in order to make these transitions safe. Okay, that's it, Cory.
Thanks, Mindy. Just want to address a quick question in the chat. Miranda, I don't know of any, unfortunately, programs that specifically focus on non-physical abuse or that specifically focus on coercive control, whether physical or not. That's a really good question. There probably, I would not be surprised if online at least, some programs are being developed, especially given the recent trend in the law with California, Hawaii, and other states. And at least in California, I mean, our success rate with batter intervention programs it's pretty hit and miss from my experience. I think studies have shown the effectiveness a little bit more often than not, a bit more than 50%. Somewhere around 60 or so is the last statistic I think I saw for California statewide. Sorry, go ahead, Mindy.
Yeah, so I can't speak to California programs, but one of the interesting take-home messages from the research is that the programs seem to help batters stop being physically violent, but doesn't help them become less controlling or emotionally abusive.
Yeah.
So we need to do better at that.
Yeah, for sure. And I think part of that is definitely not. I think we do, as Mindy was saying, we sort of view batterers or abusers, people who cause harm, as sort of a homogeneous group. A lot of our states' batter intervention programs are designed that way, right? Where it's just every abuser goes through these 52 weeks, same program, no matter what their type of case is. And I think only in some counties, some jurisdictions, like in California, the Bay Area, or Los Angeles, which are more populous and have a lot more organizations and agencies doing these programs, I think those have a bit more culturally specific. I think that kind of goes to Shelley's question, where they are like batterer programs specifically for abusers who are in LGBTQI relationships, or from this region of the world, who speak this language, to try to address those sort of cultural issues that can come into play with relationships, particularly for people whose cultures are not as widely accepted or known within the United States and clash with the quote unquote American culture, or whatever your culture is in your community. And so, yeah, I think there's definite need for those types of programs, probably more so online in certain areas of the country, I'm sure, are less resource intensive or heavy than others. So that may be a good place to go. Lily had a good question about transitioning. Yeah, I think whether or not there's a formal process, I think that kind of goes to Mindy's last point about we need something in the court order or the recommendation of the law that says, how do we transition? How do we make that change in a safe way for everybody, not only the child, but the parents as well? And I think that's going to unfortunately have to be case by case, and how each state deals with that. I'm not sure if there's some states may say if you're professionally supervised, the next step is professional exchanges, the next step is unsupervised, the next step is joint. They may be that rigid. I don't know. At least in California, it's really case by case. There's not a specific process that says, after this many, this number of visits that are supervised, you then switch to unsupervised. I've really seen a whole bunch. Unfortunately, I think this kind of first point about transitioning, one of the biggest issues I see is a lot of courts just order maybe 1 or 2 months of supervised visits without any other programs, or maybe with one other anger management for 6 weeks or something, and then they switch right to unsupervised. And I think that is very problematic because there's no built-in way for review, right? Before making that, it's just sort of an automatic switch from supervised to unsupervised. I think what's often best in a lot of these cases is having another review before you make that step, just to make sure, yes, we said 2 months ago that we wanted this change to happen and switch from supervised to unsupervised, but let's actually make sure at that 2-month mark whether or not those goals have been met, whether or not the abuser's gone through all those anger management classes or other programs that were ordered, and not only went, but did they actually successfully complete the program, right? Did they learn something from it, or did they just sit there and were they on their phone the whole time, right? That's part of where the program providers, those who are providing those classes, can really step in to provide good, informal, neutral, third-party reports to the court to inform what's to go happen next.
Yeah, and Cory, just as a lack of a transition, if I just can chime in for a second,
for sure,
because you have a parent who is using these coercive tactics go from an environment where there's 27 pages of rules about what you can't do, and we're expected to transition into here you go, you're on your own, do whatever you like, right? So that's where the gap is sometimes, where there's no bridge. And sometimes when we have so many rules about visitation, we make an artificial environment even more artificial because you're not even allowed to have bad behavior.
Yeah,
So.
Yeah, that kind of goes to the, everybody wants to be on their best behavior, and that's sort of the expectation during those times. Yeah, and so I think, thank you, people, everybody who's chiming in the chat for what your state does or doesn't do, or what you've seen in your experience. Please continue to share. I'd love to hear about what other states are doing well or could improve upon, especially here in California. We have a lot we can improve upon. But yeah, we don't have, these, like in our child welfare or dependency system, when the state gets involved with CPS and they can detain the child and then you go through dependency court. They have built in, like, every 3 months or every 6 months, there's going to be a review hearing on this case to determine what's best going forward for the child. Whereas in most states where family law, not dependency related, where the parents are the one bringing the case and not the state, when the parents do that in family law, there's not really a set of rules, unfortunately, and how often we need to update these. But part of the court order should be certainly that, going from professionally supervised exchanges, maybe non-professionally supervised, getting another third party there, like a family member or friend who's neutral and can make sure things are going well, and then eventually going to unsupervised if that's appropriate.
A step down process.
Yeah, step down, step up, however you want to talk about it. Yeah, that sort of plan.
And it seems important not only to think about a certain number of supervised sessions, that's the limit, but the quality of the interactions during those super visits. So that's where it's so important for the people doing the supervised visits to be able to document their observations, because that could be used as data to decide what else is needed, how to transition based on how things are going.
Yeah. Also, Mindy, I forgot, if you could write, you gave those great 5 risk factors from Love et al.
Yeah.
That study, if somebody was wondering if you could please type those into the chat. Just those
do you want the reference or do you want the risk factors?
Both, if you have the time. I don't know if you have it.
Yeah. I'll pull out the.
Thanks. Yeah, and then Caroline, best textbook. That's a good question. I know there are a lot of good law textbooks about domestic violence and the law. Like Professor Nancy Lemon wrote the first one back in '89 or something. Domestic violence and the law, I think that's what it's called. And I don't know of any specific textbooks on coercive control. I know there are definitely published books like Johnson and Stark. And I don't know, unfortunately, off the top of my head, any that focus on coercive control with children. But what, of course, we have some great resources in our slides and on the handout that Mindy has. And then I think the Duluth power and control wheel that I'm sure many of you are familiar with has adapted that power and control wheel to various scenarios, including relationships with children and how children can be used. And we've actually cited to that in our cases, in our briefs to the court, just to help explain, these are different ways that people can use children as a way to coerce, intimidate, abuse both the child and the other parents as well.
I'll say one more thing too, just if anybody wants more citations on anything, I tend to be an obsessive researcher and collector of research. So somewhere I have a list of coercive control citations. I don't remember what period of time it goes through, but I collect all that stuff. So if anybody is still looking for more, just send me an email. I'll put my email in the chat. I'm happy to provide resources for people.
Thanks, Mindy.
Sure.
Okay, so some hypotheticals. Okay, so now we have about 25 minutes. So as I said, we may not be able to get through them all, and that's fine. We do want to try to be interactive with these, so please feel free to use a chat. We'll use the poll feature for a couple of these. And then, so we're going to prevent some facts. As you'll see, you have the handouts yourself, so you can read along. But for those who may not have it, or they have some other impairment, I'm just going to read them as well. And then we're just going to assume that the couples we're talking about, Sam and Ash, intentionally were using unilateral DV. So it's Ash abusing Sam, A and S, have a child in common, Cal, C, just to make it easy. Those who, like me, this is what we get from law school all the time. And then with each fact scenario, we're going to ask you sort of, do you think this constitutes abuse, specifically looking at non-physical forms of coercive control? Do you think supervised visitation? I understand the question as posed here may not be the best, so not necessarily asking you whether you think supervised visitation is appropriate, but do you think in your community, from your experience, from the facts that we've presented, does this sound like the type of case where supervised visitation would be ordered or not? So I'm not asking, it is phrased here as an opinion question, and that's my bad. I'm sorry. I'm not asking for what you think it should or shouldn't be. I'm just asking more in general, do you think this would be? And sort of what do you think that look for? And then, of course, just kind of curious, what questions would you ask? Like if you're doing an intake for this family and you're presented with this information, what additional info would you want to know from the parents, from people that you talk to? So we'll jump in there. And thank you all for continuing to chime in the chat. So start with the first, or sorry, Joe, did you have something to?
No, I was just giving you a thumbs up. The way you explained that was perfect. Thank you.
Gotcha, thanks. Yeah, so in the first hypothetical here, so after years of dating, so they're not yet married, but they have a child in common, Cal. And so Ash threatened to break up with Sam, spread lies about them to their friends and family if Sam didn't give Ash her social media and email passwords. Again, intentionally using gender-neutral pronouns here just to encompass the fact that an abuser and a survivor can be of any gender, not necessarily men abusing women always. So here we have Sam reluctantly complies with Ash's demands given the threats. Ash begins checking Sam's accounts every day. A few months later, Sam ends the relationship. Ash then downloads, so with the passwords, Ash downloads thousands of Sam's emails and messages without telling them, then sent them to Sam's friends and family. Sam's supervisor from work wrote them up. Some of their friends and family have told them off, and their 10-year-old child in common, Cal, has become very upset because of what they saw from these messages. Sam became so upset that they actually had to double their therapy appointments, and Cal had to start counseling. Afraid that Ash could send more, they didn't send everything they had. Even though the Sams changed their passwords, they still decide, I'm going to file for a restraining order and try to ask for custody. So starting with the first poll, the first question in bold here. Thanks, Joe. So just yes, no, not sure, or you can skip if you want. Just wanted to get a sense, based on what we said. You can either base it on your jurisdiction, like your state, if you're really, really familiar with your laws, and you know for sure whether or not this would be included, or you can just base it on your understanding of coercive control and abuse as we've talked about it. From the social science perspective or from any other perspective, kind of what do you think about that?
Coming in pretty strong at 92%, Cory. Yes, this is abuse.
Okay, awesome. Good. And for each of these hypos, I should say, as you'll see in the presenter notes in the PDFs, hopefully, they have some citations for where I kind of pulled these. I didn't just make up all these hypos from the top of my mind. I kind of pulled different facts from different places and kind of put it together. So it's not as straightforward of a yes or no, hopefully, although it is kind of designed in a way of leaning more towards that yes, because otherwise there wouldn't be much to talk about. So yes, thank you all for chiming in. As you'll see here, there's nothing physical, no physical violence present, which again, depending on your specific state, if your state has had very narrow definition, this may not qualify. I can't say for sure whether or not. So second sort of question, again, trying to get a poll. This one's probably the more interesting one. So in your community, your jurisdiction, do you think from the facts you have here, would supervised visitation be ordered?
Yeah, this is coming in with more no's so far. We're still early here. 70% no.
Okay. Interesting. Yeah, I'm curious for those. Yeah, I guess, in every state probably has different, and every court, I'm sure, every judge has a different sort of personal feeling about, even if there's abuse, when is it appropriate to, right? Or to
It is
just,
so different everywhere.
yeah,
Everywhere in the United States, and we have some folks from Canada on the line within the different provinces,
oh, great.
within the different states. It is so different, the typical profile who gets ordered to visitation. It
Yeah.
is so inconsistent.
Yeah. And I've even seen in California, from my personal experience, like I've seen, if I get a fact scenario like this in one county, it may be granted, the judges may lean more towards supervised visit. But if I know this is presented in another county, probably not. Right. And so, yeah, it's just good to know sort of what the prevailing norms in that community is, and sort of what's appropriate. Different based on the judge's mood, that's for sure. Yeah, there are actually very, very tangential side note, some good studies out there about how judges' decision-making changes based on the time of day and whether or not they've eaten a meal beforehand. So judges are much more lenient after lunch. There's some interesting studies out there. So if you're able to, yeah, no, sorry.
I want to see those.
Yeah, curious. Thank you for those who are chiming in the chat, especially for those who said yes to the first question. No, if yes, this is abuse, but maybe no, supervised visitation would not be ordered. Kind of curious to hear sort of why. Yeah, and I think people have been chiming in with some really good reasons. Yeah, usually order mediation, then okay, yeah. Oh, then somebody else had a really good point. Whether the violence is directed at the child. Yeah, some courts, some states actually, like, for whether or not visitation is supervised, focus almost exclusively on whether the abuse was directed towards the child or not, or if they're just sort of bystanders who kind of here. Certain, I would say Cal probably, unless Ash directly, you can make the argument, unless Ash maybe sent Cal these messages directly. It's not clear from this scenario. That might be a question you want to know. Or if it's just Cal heard from others what was going on, or somebody forwarded it to them, in which case, then no, Ash wasn't directly targeting Cal. So again, yeah, it kind of depends on the situation. But yes, I think, at least in California, we have some of these case citations here down in the presenter notes, as well as some social science articles, law review articles that where these facts were kind of drawn from. I think, yes, this would be considered abuse against both the Sam and Cal, whether or not Cal was directly targeted, just given Cal did receive the information and how Cal responded. And I'm also curious, not a poll, but just more in the chat, what else would you all want to know? What additional information, what questions in your intake as you're interviewing a parent who's presenting this info, what might you want to know? Clearly disturbed a piece of the child. Yeah, that's true.
While people are thinking about that, I can just say anecdotally, over the years, I've seen countless situations, even from guardian ad litem, who are responsible for protecting the child's legal interests, say things like, well, he's a great dad, he just beats his wife, as if those things can be separated, as if it doesn't impact the child because he's abusive to his wife, but he's good with the kids. Well, if he beats his spouse, he's not a good parent. So I think people are starting to get that more, but not always.
Yeah, not only some states. I think the majority actually now have the sort of rebuttable presumption that California and others have against granting custody to an adjudicated abuser. Not every state has that, though. Oh, good. Okay, so some interesting would want to know what was the content of the emails, what was the intent, messages about the language, what's in the language. Okay, good. Thank you. Yes, this is the type of type of conversation we're hoping to sort of generate here. Just seeing what's different across the country. What are different people seeing? Jump into the second hypo here. So we're sticking with Ash and Sam, but we're going to change some of the details. So Sam ended things. Ash wanted to stay together. They were able to come to a parenting agreement about Cal. Ash thought, well, Sam's just going to change her mind. They just need some time. If I just try hard enough, so I'm going to communicate with them at least once a day. By phone call, email, text, social media, something. Sam told Ash to stop and to focus on Cal. Ash sent Sam an intimate photo of Sam that they had consensually taken while they were together, with a message saying, just a reminder, I have these. No explicit threat, nothing else. Ash then showed up at Sam's house in the middle of the day later, and what would be their, instead of 2-year anniversary, let's say 10-year anniversary, or maybe longer, depending on how old Cal is here. And Ash wants to make a big gesture. Ash eventually left after an hour when Sam threatened to call the police and then filed for a restraining order with custody. So again, same sort of questions. First, do you think this is abuse? Again, whether from your jurisdiction's definition, your state, or your understanding of coercive control. Would what Ash has done constitute that? Looks like most people are saying yes. Okay, good. Or not. Okay, good. Not sure. Yeah. Yeah. Unfortunately, with a lot of, as I was saying earlier, with a lot of these non-physical, even if your state's definition includes things like harassment or disturbing the peace, that needs to be fleshed out or explained in the cases and case law. We need court cases to say what exactly that means and whether these types of scenarios would count. Yeah. Thank you. And then the second sort of question here, I see Marcy is dealing with a case pretty similar to this. Okay. So yeah, in your community, with this fact situation presented, do you think that it's likely supervised visitation would be ordered? Here we see even more no. Actually, no. About same as last time. About a 70-30 split. Okay. More people said yes to abuse this time, but about the same for whether supervised is it. Again, curious in the chat what the if you have any explanation for those who are like Marcy, who are dealing with these types of cases, who've seen this play out. Did that work? What else would you want to know about this situation? What would you ask the parents during the intake? Some people might want to know, what was this big gesture? What did Ash do? Did Ash send any more of these photos? What all were these? Ash communicated once a day for a while. It doesn't say how long, but what were those messages? Were they threatening? Was CPS involved? Okay. Oh, so that's an interesting point. So Kira, if I'm pronouncing it correctly, Kira makes about. So yeah, some jurisdictions really may depend heavily on whether or not the governmental agency, CPS or DCFS or however you call it, is involved. They want some sort of another agency, professional agency doing an investigation. Okay. Oh yeah, what does Cal know? That's a really good question. Here, Cal's not really involved, or doesn't seem like it's really involved. Yeah, some good questions might be, how is this impacting Sam's ability to parent, or Ash's ability to parent Cal? Good questions. Thank you. Yeah, and as somebody pointed out in the chat, Robert, that this involves, as we saw with the threat, or the sort of what I would take as a implicit threat when Sam sent the photo, what we would call revenge or non-consensual porn. To me, the difference being revenge porn is more of an intent, like I'm intending to, cause revenge, whereas non-consensual is just for any intent. I'm distributing this photo, as we'll talk about.
Yeah, so apropos of that, we wanted to talk a little bit about non-consensual porn. There are 2 citations in the social science article compilation that we provided to you earlier, and they were published, I think, in 2020. 2 different papers by a researcher named Eaton, E-A-T-O-N, and colleagues. And I think those papers are really great in a lot of different ways. One was more of a review paper that talked about legislative and policy issues surrounding non-consensual porn. The other actually was a study where they culled cases from the newspapers and from media of non-consensual porn, and they categorized them in terms of how many of the spokes from the power and control wheel were represented in those acts of non-consensual porn. So I think I'm not going to go into all the details of that. You could read that in the paper. But I think the one really important take-home message that they argued for is that when non-consensual porn is transacted in the context of a relationship with other forms of intimate partner abuse or violence, that it represents a form of coercive control in and of itself. So really what they're arguing for is to call non-consensual porn a form of coercive control when it takes place in the context of abusive relationships. And I think, Cory, from the descriptions you read earlier, that this would qualify for the states that have provided legislation on coercive control, that this would qualify in those statutes, right? But yeah, good, thank you. So as you see, if you read the Eaton article, it's becoming increasingly common for people to engage in this kind of behavior, both within relationships with abuse and violence and outside of them. And again, the motivations can be different, and we don't always know the motivations, but certainly the motivations, whether you call it revenge porn or non-consensual porn, have to do with extracting control over the person whose private images or videos that were taken consensually are now shared non-consensually, presumably to shame, to humiliate, or otherwise disrupt that person's life. While it's a relatively new concept, laws have not quite caught up. There's also issues about freedom of speech based on First Amendment and other constitutional rights, freedoms that we have to say whatever we want on the internet or do what we want on the internet. It can be hard to define, and mostly family and civil remedies have not been applied. But it'll be interesting to see how that plays out with these new coercive control laws that will capture this. I testified a couple years ago, I think 2 years ago maybe, in an appeal of a protective order that was denied by the judge. This couple was separated or divorced for already 7 years, and there was all kinds of ongoing stuff, including non-consensual porn. And I testified about that, and the judge just stopped me. He's like, "Is that a thing?" It was, of course, like some old white dude, and he had never heard of it and didn't imagine how this could actually be disrupting her peace and be something that would cause emotional distress and harm to her. But hopefully judges are getting trained and they're understanding the new technology-based ways in which people can continue to harass and threaten and abuse the others. So, again, when this takes place in the context of a relationship, there's often co-occurring violence, other types of coercive control, threats, minimization, physical and emotional abuse.
Thanks, Mindy.
And I urge you to read the Eaton papers. I think they do a really great job of addressing these issues.
Yeah. Thank you. And I'm very sorry, y'all. Even though we cut this down from what we had previously, I think just great participation in the chat. Awesome. Thank you. I really want to respect everybody's time, while also just acknowledging we do have some additional slides we unfortunately won't be able to get through. So just wanted to note that these are here. So as I said, if you have time to go through these on your own, look through the hypos, look through the presenter's notes for the citations, discuss them with your colleagues if you can. If you have questions, if you don't agree with what we've said, my email is in the chat at the end. I guess here, lastly, yeah. So I'm sure this is a big topic for a lot of people, the pandemic, and sort of how you're seeing this play out. And I would be really curious to hear in the chat what this is doing for you. But as a part of our coercive control law, which was called Senate Bill 1141 from last year, went into effect this year, we actually had legislative findings tying domestic violence to COVID-19, which is in part because at the time the legislature really legislators could only bring forward a bill if it related to COVID, just given everybody was on lockdown and everything, so they were limited. So they had to tie it to COVID. But as we saw, I'm sure many of you providers saw, an uptick with DV. A lot of DV providers, like shelters and legal aid providers, also reported an uptick in calls, both higher rates, so like across the board, just more of it going on, and unfortunately, more severity, higher severity. So not only this, as we were talking about, a lot of this more low level, pushing and shoving, but more higher level things, right? Physical punching, kicking, strangling, especially even strangling somebody for 5 seconds could be lethal depending on the situation. So that's very serious. And we saw increase across the board, even in other states across the country. Again, look at the presenters notes, you'll see that. And this was in large part because with a lockdown came isolation. A lot of providers were closed. Courts even were closed. I'm sure a lot of us saw. People couldn't go to court to get protection, to get custody orders, to change custody orders or something. And being locked inside, just given the nature of this issue being domestic violence, you're locked inside with the abuser, right? And there's, especially with child abuse, a lot of the external providers like teachers and doctors don't have the access to the child. So even though they're mandated reporters, they wouldn't be able to view that and offer help. Even same with adult victims who may otherwise, like their coworkers or their friends who they otherwise normally see during the day. It's hard to assess what's going on virtually with somebody. So we just saw a huge increase in DV. And we've seen it used, unfortunately, against victims, both to keep them isolated from support, but also isolated from their children. So as we saw with the previous hypo, as you can kind of go through on your own, that is specifically about Ash using the pandemic and Sam's position as a nurse or a healthcare provider against them. So yeah, definitely just want to highlight this. And
it sounds like a great promotion for an upcoming webinar you guys should deliver, because it's a huge issue with us in Visitation. And we've actually, Karen Omi out of Florida State University recently published an article about some of the unintended consequences of COVID-related visitation and virtual and the dangers of virtual visitation that nobody looked into. So could be an interesting topic for future reference to talk about how COVID has changed our world and how virtual visitation has been a really great asset, but it also presents some new challenging opportunities and ways for coercive power and control types to inflict more abuse. So
right, unintended consequences.
Exactly. So I see you guys have your contact information up. Yeah, thank you so much for all the great information today. Again, this PowerPoint is available, and you will be able to go to the resource page on the SVN website, which we'll send you a link to as this presentation closes. So you'll have this information available there as well. And you'll also have an evaluation form that'll pop up. Please give us your feedback. We'd love to hear from you. But on behalf of SVN, our membership, our board of directors, thank you, Cory and Mindy, so much for your time today. It was a great presentation. Thank you.
Thank you.
Thanks.